Good day, Crime Talk aficionados. Attorneys for Richard Allen, remember the Delphi murder suspect, say that she has got to go for not doing her job. How the jury was voting in the Karen Reed case. Day 2 update for the Alec Baldwin trial. We have an update on that guy arrested for dumping a body as he dragged it down the street in his wheelchair. A horrible DV case in Mississippi. A drunk driver runs into a business and kills many, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can listen to us anytime on any of your favorite podcasting apps. Let's go ahead and get straight to the docket for July 11th, 2024, and first on the docket, the Delphi murder. That's right, the defense attorneys for the man accused of killing 2 Delphi teens has asked the Indiana Supreme Court to appoint a special judge to rule on motions that they've made in front of Judge Frances C. Gull, and she's not ruled on them. So Richard Allen's attorneys filed a petition with the Indiana Supreme Court to determine whether a ruling has been delayed beyond the time limitations set forth under various rules there in the state of Indiana. Now, the defense specifically mentions that several motions they have made in the case have not been ruled on by Judge Gull. The defense has filed several Franks motions, the third and fourth of which have yet to be ruled on by the judge. Now, I'm sure she could just pencil whip that denied across those motions like she did the previous motions. She does not give anything the defense says any weight or credibility whatsoever. Now, the defense says, hey, it has been 119 days since they filed their third Franks notice, 72 days since they filed a fourth Franks notice, and 64 days since the court said it would rule on those motions. Hop to it, Judge. Anyway, according to the defense, Indiana trial rules say that if a court fails for 30 days to set a motion for a hearing or fails to rule on a motion, the submission of the cause may be withdrawn from the trial judge and transferred to the Supreme Court for an appointment of a special judge. So we could have special judges in the Richard Allen case. I think that would be interesting. I personally don't think Judge Gull's doing a great job. She's not even given an appearance of trying to be fair to Mr. Allen, but we'll have to wait and see. Anyway, the defense also argues that there is no hearing required on the motion, and this court still has not ruled on them, and it's been more than 30 days. Now, Mr. Allen's attorneys are not asking that the delays recorded in the case history and that the history be promptly forwarded to the executive director of the Division of the State Court Administration so that they can get a new judge. Now, that entity would decide if the delay did occur, and if they rule it did, Allen's attorneys request the case be submitted to the Supreme Court of Indiana for appointment of the special judge or other actions that the Supreme Court deems appropriate. Now, I've never heard of such a rule, obviously clearly unique to the state of Indiana. It's a good rule. Sometimes judges have a tendency to not rule on motions in a timely manner. I had a case once years ago. Literally, it was in federal court. This judge is now deceased. We waited 2.5 years for that federal judge to issue an order denying the motion to suppress wiretaps. And it would be no big deal, I guess, if you were out of custody. But this was a multi-co-defendant case, and the majority of the defendants were all in custody. 2.5 years. If you're going to deny it, just deny it, Judge. Let's move forward. Anyway, seems like a good rule. Never really heard of it. Don't really have that where we practice. Sometimes you just got to wait it out. Next, the Karen Reed trial. Couple of things. We're going to find out that what the vote count was for the jury, allegedly. And what's this trooper Michael Proctor? Is he really going to get in trouble? Now, we brought you the story that he's been suspended without pay for his actions as the lead investigator in the Karen Reed case. Now, a lot of people think that he's got some real problems coming his way. I tend to agree. Now, as you may recall, Proctor was called as a witness to testify, and he had to answer questions about, some of those derogatory text messages that he sent to his friends and family and other colleagues about Miss Reed. The most, I think, one that jumps out at you is the fact that he says that the trooper, now telling his friends and family, hopefully she kills herself, referring to Miss Reed. And while searching Miss Reed's phone as part of the investigation, he said to supervisors in text messages, "No nudes so far." Anyway, like I said, he's been suspended. The State Trooper Association, the Police Protective Association, said that they are obviously disappointed, but they don't know what the basis is. So they're assuming that it is in relation to his actions as the lead investigator. But there's also that pesky federal investigation that's going on. And so we'll just have to wait and see. Like I said, those derogatory messages certainly don't look professional, to say the least. And the other issue is that, it could be a violation of various privacy issues that could come up. Sharing this information with friends and family, not really supposed to do that. Now, is it criminal in that regard? I don't know. But if you plot to have somebody convicted for a crime they didn't commit, certainly that's much more significant than a few derogatory remarks in text messages nonetheless. However, if I was Mr. Proctor, I may be freshening up that resume because he's going to have to work because the suspension is without pay. Now, as we talked about yesterday briefly, the union will do what the police unions do and say, he did nothing wrong. You can't fire him. How dare you do this? They will protect him to the bitter end. That's what unions do. They're little union stewards. And regardless of how egregious the conduct is, they will do that. That's always been the problem with the police, is that they don't police themselves. They will fight to the bitter end for the most corrupt of them all. So hopefully that doesn't take place. The union will do what they got to do, I guess. But hopefully if the feds are going to charge somebody, let's do it. Let's do it. Let's have this internal investigation get wrapped up as quickly as possible. Why? So the prosecution can decide if they're going to be able to go forward. Everything right now is kind of in, somewhat of a holding pattern, simply because obviously they need to reset the trial if the prosecution is going to go forward. But you'd also think if your lead investigator is facing potential criminal charges, that may be one indication that this case should not go forward. Just something to think about. Now we are receiving information that we haven't some insight as to what the vote was on the various counts as it related to Karen Reed. Now, as you know, the Karen Reed trial resulted in a mistrial after almost 30 days of trial, several days of jury deliberation. And ultimately, the jury sent out a note that said, we are deadlocked. The judge said, fine, I'm declaring a mistrial. Unbeknownst to the judge, the prosecutor, and the defense, allegedly, the jurors had reached a decision on a couple of those counts. So a juror in the Karen Reed trial has come forward, apparently, and is corroborating the defense's assertion that the jury unanimously voted to acquit her of murder and stated that it would be unjust to retry Miss Karen Reed. Now, let's wait a second. Apparently, these jurors described the final day of the trial as a whirlwind and somewhat confusing. So apparently, after the judge declared this mistrial, jurors were taken away on a bus, questioning if anyone would know that they had actually acquitted Karen Reed on counts 1 and 3, as no one had asked them about those counts. That's what we talked about when we said, yes, the Karen Reed counsel kind of blew it, and so did the prosecutor, and so did the judge, because they could have inquired, have you been able to reach a unanimous decision on any of the counts? But frankly, the notes that the jury was sending wasn't indicating that they were in agreement on anything. The way those notes read, it sounded as though they were deadlocked, whatever the count may be, but that they weren't going to reach a decision. They didn't say on one count. They made it sound like all counts. So this is what happens when you don't ask those questions, so to speak. But, you can't ask questions these days, right? Oh, maybe offend somebody, right? Anyway, So on the charge of murder and leaving the scene of the accident, apparently, according to this juror, the vote was 12-0. It was unanimous, not guilty. But they were deadlocked on one charge, the vehicular manslaughter. Now, wait for it. All those Karen Reed lovers and haters, the vote was 9-3 in favor of guilty. So my guess is the reason why the defense probably didn't ask for a mistrial is they had a feeling that there was something going on. They wouldn't have known, but they had the feeling. They had a feeling that maybe the jury, there was obviously clearly at least 3 people that wanted to convict her on something, and they wanted to get out of there as quickly as they can. Now, we'll see what the judge does on this case. The jury never was presented. The judge declared a mistrial before the jury was able to read those decisions. I could be wrong, but I don't think the judge is going to say I'm going to enter judgment of acquittal as it relates to those 2 particular counts. Now, the fact that a jury did in fact find her not guilty, at least in theory, and unanimously to do that, the prosecutor should know that information. And if they go forward, they may want to only go forward on the vehicular manslaughter charge versus going forward on all of the other counts. It's basically the same evidence, but clearly somebody wasn't buying what they were selling on those 2 counts. So like I said, the judge declared that mistrial, and no one ever disclosed the vote count. Now, Reed's attorneys then filed this motion, pointing out that the prosecution should not be allowed to retry the murder case because it would amount to double jeopardy, which by law means you can't obviously be tried again. I know there's a case cited in the brief. I get it. I just don't think the judge is going to do it. We'll have to wait and see. We'll be surprised together. We'll find out, just like we do when a jury verdict is in fact read. Anyway, according to the filing by the defense, the juror says that the jury believed they were compelled to come to the resolution on all counts before they could or should report verdicts on any of the counts. As for what allegedly happened, prosecutors contend Reed got into an argument with her boyfriend, police officer John O'Keefe, back in 2022 before hitting him and running him over with her SUV and then fleeing the scene after a night of partying with friends. Obviously, Reed's legal team disagrees with that theory, and they argued that the police framed Miss Reed after she dropped off O'Keefe at a house filled with cops having a celebration. During their little get-together, the lawyers argued that O'Keefe was killed after a fight broke out, and he was then dragged outside and left for dead in the snow. Also, the defense contends that officers pinned the crime on Miss Reed because they wanted someone else to take the fall. Now, during the trial, the defense also discredited the case lead investigator, like we talked about, because, unprofessional conduct. Prosecutors say it's not over yet. They plan to retry this case, and we'll see what happens in a couple of weeks when we have that status conference. It's a big mess, and who do we blame? Ultimately, the judge. She should have been responsible for clarifying these things. Things are done differently in all places, but jurors can ask questions. They were quite eloquent in their statements to the judge about how they were deadlocked. They should have said, could have said, we've reached a verdict on 2 counts, but we're hung on the 3rd. What should we do? The judge could accept the verdict on the 2, mistry on the 3rd. It's just the way it goes. Welcome to the justice system, ladies and gentlemen. But I think what was interesting is they were going to convict her, or at least 9 people were going to convict her. 9 jurors were going to convict her on the vehicular, was it assault or homicide? On the vehicular assault charge. Very, very interesting, which makes at least 9 people believed she was the driver. Something to think about, ladies and gentlemen. I know there were a lot of people out there that were completely on Karen Reed's side, but apparently the jury said, hey, this isn't murder, but it's probably vehicular homicide, right? When you're drunk and you hit somebody, you kill somebody. Yeah, they think she was the driver. That's why the defense asked for that mistrial. They're like, I got a feeling. Trust me on this one, ladies and gentlemen. Don't doubt me. Next, an Alec Baldwin update, day 2 of testimony. Now, Alec Baldwin's attorneys continue to grill the state witnesses on the investigation into the shooting on the Rust set in Alec Baldwin's manslaughter trial. Now, Mr. Baldwin was practicing a cross draw in a church on the Santa Fe set in the Western in October when the Colt .45 revolver fired a live round, obviously fatally striking the cinematographer Helena Hutchins. The director, Joel Souza, was also injured as well. Now, during cross-examination, the defense attorney questioned a crime scene technician on how thorough the probe was into the source of the live bullet, including the source of the prop store in Albuquerque where the ammunition came from. When questioned about how extensively the investigation searched the business, the technician, a woman by the name of Marissa Propel, was responsible for collecting some of the evidence in the case, said that the Santa Fe County Sheriff's Office team reasonably searched the warehouse. When she was asked if the team collected surveillance footage, which was listed on the search warrant, she didn't recall looking for that. Isn't it the truth that you were just trying to get this over with so that the prosecution could focus on Alec Baldwin? Mr. Defense Attorney asked Mr. Spiro. No, she responded. Spiro then alleged to Ms. Propel on cross-examination about damage to the revolver involved in the shooting that occurred. Spiro then asked Propel about damage to the revolver involved in the shooting that occurred during the FBI firearms testing, asking, quote, "At the time that this testing was ordered, you knew that the firearm would no longer be the same physical condition when you recovered it, correct?" "Yes," the technician said. Now, Mr. Spiro said during opening statements that Baldwin wasn't given the chance to have the gun tested in its original condition, preventing him from being able to show his truth. Now, Mr. Baldwin has maintained that he did not pull the trigger on the firearm, though the FBI forensic report determined that the gun could not have been fired without pulling the trigger. Also during opening statements, the prosecution argued that Baldwin behaved recklessly and violated the cardinal rules of firearm safety. Don't point the gun anyone, ever. Anyway, the defense, meanwhile, maintains that the actor committed no crime, and this is just an unspeakable tragedy. And there's the most critical issue in this case is how the live bullet got on the set. Anyway, Ms. Propel ultimately testified that there is no evidence that Baldwin brought a live round onto the set or loaded the live round into the gun. During redirect, though, the prosecutor asked Ms. Propel that Baldwin wasn't charged with involuntary manslaughter for bringing the live rounds onto the movie set or for loading a live round into the gun. Isn't that correct? That's correct, right? Because the person that was responsible for that, under that theory, has already been tried and convicted. That's right, Hannah Gutierrez. Gutierrez was found guilty of involuntary manslaughter in March, and they say that she repeatedly failed to maintain proper firearm safety and brought several live rounds onto the set, including the one that killed Miss Hutchins. Now, her attorney has stated that they have been notified that Miss Hannah Gutierrez Reed will be called to testify on Friday and plans to invoke the Fifth Amendment. Now, that should be done outside the presence of the jury, and the judges ruled that she's not going to force Miss Hannah Gutierrez Reed to testify under a grant of immunity. So, could that go well for Mr. Baldwin? Yeah. Could it go bad for Mr. Baldwin? Yep. We'll just have to wait and see. Join us tomorrow. We're bringing you gavel-to-gavel coverage here on Crime Talk. Now, there was some other kind of motions, hearings, issues that were done outside the presence of the jury today, and the judge denied some portions of a transcript from being admitted, but did allow in part where Baldwin talked with his wife and another person about a planned family trip to New Mexico. The judge said that Baldwin was looking to convince his wife. The prosecution was arguing that Baldwin was looking to convince his wife to still come on this vacation because they can't get their money back for the plane tickets, and they'd like to go ahead and have a good time. Now, Baldwin at some point left the courtroom when Morrissey read a part of his interview that she said spoke to his motivation to lie about pulling the trigger. That portion says, "I'm 63 years old with 6 kids. I can't rely on luck anymore." Baldwin is stated in the transcript. He's talking about his career and that he can't rely on luck anymore. And this goes exactly to his motivations not to tell the truth. That's what the prosecutor is arguing. Now, the judge said she didn't think that information was that helpful, but said, hey, I'll go ahead and allow it because of the lateness, regardless of the lateness of any redactions. So once again, ladies and gentlemen, this is what people oftentimes forget. When you are a defendant, anything you say can and will be used against you, taken out of context, misconstrued, and used against you. Okay? Bottom line. That's what it boils down to. And that's what happens here, right? He's having a general conversation. You know, I'm 61 years old. I don't rely upon luck. Now they're saying that's basically his lying about, that's motivation to lie about his involvement in this shooting. Obviously, that's for a jury to decide, and they have to determine what weight to give that particular statement. Could it just be, man, like, this is terrible. You know, I'm a 63-year-old actor with 6 kids, and, you know, I'm getting older. This one's got to work, right? Is that a fact, or is that a cover-up of a lie? We'll have to wait and see how it ultimately plays out in court. Like I said, we are bringing you gavel-to-gavel coverage of the Alec Baldwin trial. Have a quick update on that guy that was dragging the body down the street with his wheelchair. Yeah, Chad Irish. He has been charged with second-degree murder 2 days after he was taken into custody for the death of Yasmin Williams. Police have alleged that Williams was shot in the back of the head before her body was discarded next to a pile of trash last Friday on a street in New York. Surveillance video. It basically shows Mr. Irish pulling a sleeping bag on a dolly with the help of his motorized wheelchair that he finds himself in. As he's zooming along with the suspected corpse in tow, he appears to hit a snag and stops to readjust the sleeping bag and trash bag placed on the sides of it. Anyway, as Mr. Irish was wheeled out of the police station yesterday and loaded into a police van, the alleged killer appeared very disoriented, flustered, and confused by questions from reporters about whether he in fact did it. And his response was, "I don't know what bag you're talking about. I know not of what sleeping bag with a body in it being towed behind me in my wheelchair that you speak of. I have no idea." Anyway, Irish is also facing counts of second-degree criminal possession of a weapon and concealment of a human corpse, which was filed against him earlier in the week. At least 2 residents in this housing facility where Mr. Irish lived said that they had concerns early on that Mr. Irish was involved with the disappearance of this young woman. One individual asked the young Mr. Irish what you did with that young girl, and they asked him repeatedly, and he says it was garbage. Accordingly to the man that knew him, it was garbage, it was dirty clothes, and he had to put it out. Now, Mr. Irish, even though he's now in a wheelchair, has a history that includes at least 21 previous arrests. And he apparently also has a twin brother who uses the same name, so he's on parole and also has a criminal past. So maybe some of those arrests are confusion with him and his brother. Anyway, don't worry about it. It looks like he's living at state expense in government housing. Now, Mr. Irish was also charged with menacing and weapons charges in the week and on an unrelated matter to this. We'll have to wait and see how that one turns out, ladies and gentlemen. Like I said, if you can't believe the video from the surveillance, I don't know. What can you believe? You can't believe anybody these days. Do we believe anything that's on video? I don't know. It could all just be a big, deep fake. For those of you who know what I'm talking about, you know what I'm talking about. Next, a horrible DV case. This is a judge's worst nightmare. That's why judges shouldn't necessarily do this, i.e. let somebody out or reduce a bond. So a judge lets a domestic violence abuser out, and guess what he does when he gets out of custody? He allegedly goes and kills his girlfriend. So the body of Lauren Johnson, her mutilated body to be more accurate, was discovered in the back seat of her car the other day. The man charged with her murder, her ex-boyfriend, Bryson Rivers, and he was released on bond for a violent felony just days earlier. Now, back in December of 2023, Mr. Rivers was arrested by Nashville Metro Police and charged with aggravated kidnapping. Johansson's father, Lance Johansson, stated that Rivers brutally beat his daughter and held her hostage while the two were on vacation in Tennessee. He also said that he warned a Nashville judge that if Mr. Rivers were to get out of jail, he is dangerous. Anyway, the dad says, I sat in that courtroom in Nashville. I told the judge that if they let him out, he's going to kill my daughter. He had assaulted her. This was probably the 5th or 6th time where they would get into a fight and he would beat her. He would get away from her, for a while, but he would find his way back in. You know, the whole domestic violence, cycle of violence thing, ladies and gentlemen. I tell you, you beat my daughter one time, let alone 5, 6 times, guess what? Oh, we're going to talk. We're going to have problems. I know people. Anyway, according to the district attorney's office, they say, hey, the bond was originally set at $250,000, but the gentleman had lingered in jail for 7 months, and then ultimately his bond was reduced to $150,000, and the DA said that they objected to that reduction. It was the judge. The judge that did it, just for people who are curious, is a Judge Cheryl Blackburn. As a part of an agreement with Rivers and the defense attorney they said that the family was to be contacted if there was any change in Rivers' status, and he was supposed to be fitted with a GPS ankle monitor. That didn't happen. They let him out, and they didn't tell anybody, and they didn't put an ankle monitor on him. They just let him walk out of the jail. Now, ladies and gentlemen, we keep talking about these public officials. No one ever has any consequences for their actions. Oops, sorry. Yeah, maybe you can do it. Maybe if somebody went to jail, right? We keep talking about this negligent stuff. I think they fell below the standard of care of what a reasonable pretrial officer would do and the jail would do, which is make sure that he was fitted. Charge every one of those people with a negligent crime. Do you think? Something to think about, right? Should everything be negligent? But they screwed up. And my guess is no one will ever be fired. Nobody in the government ever gets fired for being incompetent. They get promoted. Anyway, the following Monday, on July 1st, Johansson received a voicemail from the district attorney's office warning him about Rivers' release and he wasn't being tracked on the GPS because they forgot to put him on. Oops, sorry about that. The exact voicemail says, hi, this is Bailey calling from the district attorney's office in Nashville. Bryson Rivers was released from custody. He was supposed to report straight to GPS company and to be put on for a GPS monitor, and he was not supposed to leave Davidson County. But as soon as he was released, he did not report to get the GPS monitoring, and he has not been heard from. I just want to make sure that Lauren is safe. Well, Lauren wasn't safe. And oftentimes those GPS monitors are put on before they leave the jail, ladies and gentlemen. Anyway, Johansson said that he called his daughter and she did not answer. When she texted him, it didn't really look like the way she talks. So on Tuesday morning, Johansson said he woke up around 4 a.m. and received a notification that his daughter's Life 360 tracker was turned off. Then he received a call from his younger daughter who was living with Lauren. She said that Lauren was not home, the front door was left open, and their security camera was destroyed. Needless to say, the family contacted the Hattiesburg Police Department, and the dad said, when I got up in the morning, I called the police. There was no communication. They didn't do anything. We assumed they would track the vehicle, try to find her, but they never did until Wednesday at 3 o'clock the following day. Anyway, they did ultimately track Lauren's vehicle through the OnStar service, and when it pinged in Harrison County, they called Lance Johansson, and he said, I knew it. When I received that call, I knew that she was dead. When we got there, her car was in the middle of the cemetery, and she was in the back of the car wrapped up in sheets and a trash bag. She was beaten to death. Her face was smashed in. Her head was smashed in. She was brutally beaten to the point that she couldn't see out of either eye when she finally died, and there were multiple holes in her head. The dad helped the coroner lift her body out of the car. It was totally mutilated. Anyway, the father has stated that he could not believe that Rivers had been let out of jail with a reduced bond and no monitoring system. He says that he thinks the criminal justice system in Nashville, Tennessee failed his daughter and his family, and the world shouldn't work this way, he said. She was very beautiful, super smart young woman with dreams that were larger than life. Everything she did, everything she touched turned to gold. Lance Johansson, the father, he just happens to be an orthopedic surgeon, and his daughter Lauren was attending the University of Southern Mississippi to get her nursing degree because, according to her father, she loved helping people. Tragic story, ladies and gentlemen. Those DV cases are the worst. They really, truly are the worst, and it's so predictable. So predictable. Past performance is indicative of future results. Next, take a look at this video. Drunk guy crashing into a building. Yep, one of the most preventable crimes you could possibly have. DUI. Take a look at this video. A man was behind the wheel of an SUV and drunk when he crashed into a Long Island nail salon, killing an off-duty New York Police Department officer and 3 other people. The Suffolk County Police arrested Stephen Schwally of Dix Hills and charged him with DWI after the crash in Deer Park. Now, the 4 victims killed in the crash have been identified as Meizing Zhang, Yan Zhu, and Jisia Chen, and Emilia Renhack, an officer with the NYPD. 9 other people, including a 12-year-old girl, were injured and rushed to the local hospital. 1 person had to be airlifted. Police say that Schwally was among those hospitalized. He suffered non-life-threatening injuries. Of course he did. Anyway, they say that he will be arraigned on the charges. Now, like I said, the SUV was swerving before it crashed right into the Hawaii Nail and Spa, and bam, that was about 4:30 p.m. Horrible. Needless to say, it's traumatizing to everyone. Our condolences go out to all the victims in that particular case. Absolutely terrible. And of course, everybody in the government is outraged and shocked. And the reality of it is that it was a preventable crime. You don't drink and drive, ladies and gentlemen. You don't drink and drive. It's bad enough when somebody has a medical emergency and they crash into somebody and somebody dies, but this was 100% preventable. And Mr. Schmally, guess what? You're going to prison. You're going to prison for a very long time. Now, I'll give you the presumption of innocence, but let's just assume hypothetically you are convicted, and guess what? You are going to prison. And then finally, our dumb criminal of the day, something you just don't see every day. Prosecutors have charged a Pennsylvania man who works as a professional clown with moonlighting as a hooker. Francis Bowie was named in a criminal complaint accusing him of promoting prostitution. It's a misdemeanor, so he's got that going for him. Bowie is known professionally as the Amazing Franco and has performed nationwide at county fairs, schools, and other venues. Now, according to the complaint, Mr. Bowie was arrested in mid-May in an undercover operation launched by police in Pennsylvania, where Mr. Bowie resides. Investigators monitored online posts offering escort services in the Scranton area, discovering an ad offering sexual services by a male later identified as Mr. Bowie, who included his phone number with some sexually explicit photos. In a subsequent text message exchange, the suspect allegedly offered to perform condom-free sexual acts on the undercover and quoted a rate of $100 per hour. The cop agreed to the price and arranged for a little romantic rendezvous. But when Mr. Bowie showed up at the hotel, he was arrested because it was an undercover sting. Anyway, Mr. Bowie admitted, hey, this is really my first time prostituting, and saying that he knew what he was doing was wrong. Now, Mr. Bowie told the police he is a professional clown, and he recently got back from traveling with the circus. And the performer, according to the police, stated that money was a little low, so he, had to do a little side hustle to bring in a little extra income. The phone number in the escort ad also appeared on the Amazing Franco's Facebook page, which apparently has been deleted. Like I said, you can't make this stuff up, ladies and gentlemen. August 16th is set for the preliminary hearing. All right, everybody, that's all we have for today. Thanks for watching. We'll see you tomorrow. remember, the Constitution matters.